We are back on MorningLine. Thanks for joining us. News Channel 5 legal analyst Nick Leonardo here. A lot of things in the news, legally speaking, we're talking about this morning, including a change in the law with regard to those who are serving time because they were selling drugs within, or selling, not necessarily selling, but carrying and caught with.
Selling.
Do they have to be caught selling it?
Manufacturing, distributing, it's based upon the weight. The amount of the drugs.
Okay, but selling, but if you're caught with that amount of drugs,
presumption that
there is a presumption within 1,000 feet of a school. Now, there are
or daycare.
Or daycare. What's changing on that regard?
Well, so back in 2020, there was a big push in the General Assembly, and they did away with this drug-free school zone thing and modified it. Well, here recently, there was a new bill that just went to the governor, and it's going to go into effect in July. And it says if you were convicted before, I believe, September 1st of 2020 of a drug-free school zone violation, you could come back into court and be resentenced. And if the sentence in the court looks at it and says, look, if we resentenced you, it would be lower than what you got because of the school zone violation, then the court can resentence that person, and they will get a reduction in their sentence. And so, you know, normally after being in the Tennessee Department of Corrections for more than 120 days, the trial court can't do anything. Judge Blackburn Dozier, Judge Dalton, they can't help you. You're done. It's up to the parole board and the governor. Well, this confers jurisdiction back onto the trial courts to look at this, and there were a lot of mandatory sentences that people got as a result of drug-free school zones. And what would happen is that in a metropolitan area like this, they would let a drug deal go down, and then they would follow these people and let them drive through several school zones and charge them with that, knowing that that was a bargaining chip that the prosecution had to make them plead guilty because there was mandatory jail time on these sorts of things. And so everybody came away a felon, everybody got a little jail time, but they didn't get the max that they could have. And so there are even times where the police with a confidential informant would set up a drug deal, okay? And it would be as the crow flies. We'd sit here and look at Google Earth and draw straight lines and all that kind of thing on these maps, but now they've changed that. I think that's the right decision, obviously. But now the people that were convicted before then can come back and have their sentence overturned. But something that we're seeing, which is incredible for the Republican legislature, you know, to come up with some sort of bill like this. And there's been a lot of, last July, there was a ton of criminal justice sentencing and other kind of reforms out of this Republican General Assembly. And I think it really is the right result. But I think they got there because they didn't want to spend the money building more jails.
Well, that's it. It's the cost, locking people up. And my understanding is that this could right now affect at least 400 people, maybe more.
But what about the people in Colorado and Illinois and Oregon, all these people that are locked up for copious amounts of marijuana that's now legal, right? I mean, I think we could start to see more and more of this change in thought. Or what if, you know, our district attorney's not prosecuting small amounts of marijuana anymore? Well, it used to be that if you got your fourth offense, it could be charged as a felony. And so let's say you have a felony because it was the fourth time they caught you with $50 worth of pot, and now you're a felon. Well, that's not right, because now we're not, even though it's not a change in the law, it's a change in perspective and it's a change in policy. But I'm glad to see that there are some bipartisan things that we can agree to. But again, I think the fiscal note, and of course this bill says the fiscal note is unknown, is what this bill says from the General Assembly. They're not quite sure how it'll affect things, but the truth of the matter is we get more and more people out of jail for drug offenses, and then we can have more room to put the really bad folks in jail who are harming individuals.
It's going to be interesting, but I think it's the right move, because ultimately, I've said time and again, I mean, if they got to be locked up because they're a threat to public safety, great. Otherwise, I don't want to pay for you to get, you know, 3 hots and a cot. I'm sorry, I'm just not up for that. Well, let them out, be on probation, whatever. I'm sick and tired of paying to lock people up who are not a threat to society if they caught with a minor amount of drugs. Because it's just crazy. We're just going to keep, just lock them up, throw away the key. You do like paying for that? Well, I don't. Now, if it's a threat, I'm all for it. Don't let the murderers out. But boy, a lot of this other stuff's like, well, geez, man.
Another thing we've seen as of last July, that if you're placed on probation, you're not allowed, there's drug testing, right? And so if you fail a drug test for the first time, I think the judge could only give you 15 days. He can't, you know, put you in jail for a long time or put your sentence into effect. The next time, I think maybe 30 or 45, the next time 90. And so what we're seeing a change on probation is that if people have substance abuse problems, we can work with that. But the one thing that will get your sentence placed into effect or get the book thrown at you is that if you get new charges while you're on probation. Yes. So there has been a shift to say, like you're saying, look, just because somebody keeps smoking weed on probation, I don't want my tax dollars going to incarcerate that person continuously because they're really not a threat necessarily.
But if they commit another hardcore crime, then that's different. Totally agree with you. Hey, we just got 4 minutes left. Real quick on this one. We both are waiting for Michael Cummins to finally stand trial. He's at Riverbend. He's the one that's charged in the Sumner County mass murder, just a horrible case where he killed most of his family. And the issue is, from what I understand, the DA says he's not sure what exactly the mental state is, but they have not, unlike Travis Ranking in the Waffle House case, that he is still more or less just mentally unfit to stand trial. I don't know that that is officially what's laid out there, but there's no reason for the delay to continue at this point. It's not like people are asking for extensions. I just don't think he's been cleared to stand trial. In a case like this, I mean, can that go on perpetually? And do you have an idea of what it takes to get him fit to stand trial like they did with Ranking?
Well, I mean, we saw Judge Fishburne, accepted the fact that Ryan King early on was not, mentally competent to stand trial. But so they sent him out to MTMHI, wherever Middle Tennessee Mental Health, or wherever they would send him, and got him to a place through medication and other things to where they believed that he was competent, which is a very low threshold. I mean, competency to stand trial means that I can communicate with my lawyer about what happened. Right. And I'm understanding what was going on versus somebody being in a vegetative state that can't even communicate, okay? And so obviously that's all they've got to go on. There's a lot of witnesses. They know that this individual is, Ray Whitley's got a slam dunk here, okay, without a doubt. But that's what we've got to do, is make sure that that person is indeed competent, and that's a low threshold. And I think that at some point they can get this individual competent. And
it's typically the doctors that have to make that call that
Correct.
are evaluating
It's not the judge. It's not that the judge and the lawyers accept and read all these medical reports and choose whether or not to accept the findings or the recommendations. And so it's the doctors, the experts in this case, that would opine if this individual was competent, or if this individual could, through treatment and other means, become competent.
And competency means he can understand the charges against him and maybe assist his attorneys?
And assist his attorneys in the defense and be able to, describe those, not describe, but be able to talk about, and say, okay, Nick, this is what happened. I was drinking that night. I got into a fight with such and such. And the lawyer's able to say, you realize that you're looking at life in prison. The state is, offered you, 60 years or something. But you have to be able to communicate with your attorney, because you have to have the effective assistance of counsel. And at the end of the day, we don't want to try the case twice because a higher court finds that he was not competent to stand trial, okay? So we want to get all this out of the way early on, so that when we put him away forever, we don't have to keep spending taxpayer dollars redoing this matter.
Gotcha. It's going to be interesting to see how that develops. A lot of people waiting for that case, but I think you hit it on the head. It's more or less a slam dunk for the DA, Ray Whitley, based on the evidence they have. There's no question that this individual was involved. It may be another insanity plea. I'm not sure how that'll play out, but just a horrendous crime.
Is that case sealed too? Is that?
Yeah, some of the details of that are sealed. As it's moved forward, there have been some, a lot revealed during hearings to this point, but it's been a while. He's just sitting there over at Riverbend, and I don't know what the delay is. It was supposed to start. Trial was supposed to go earlier this year, and it's been postponed.
Well, defense attorneys never met a continuance they didn't like.
Well, that's true, and I don't think Cummins is going anywhere anyway. So, hey, Nick, always a pleasure having you on.
Good to be here.
We'll see you again soon. We're going to take a break. I'll have a programming note right after this. Stay with us.